Hi, my name is Anthony Alder from Alder IP, and welcome to another episode in the IP series. Today we'll be talking about a little bit of an update about software patenting in Australia. Software patenting in Australia has been changing on a rapid pace in the last year, and this is partly because of decisions that have come out of the federal court in Australia. Now, the federal court's one of the major courts for dealing with patent disputes, and if you go from federal court, the only place you can appeal from a federal court decision is to the High Court. Typically, the High Court in Australia only takes on cases selectively, which means that to go to the High Court, you actually have to seek special leave from the justices of the High Court, and they have to actually be interested in your case before you could actually go to the High Court. And typically, the High Court hasn't had much of an interest in patent fields for whatever reason. Just recently, the High Court has agreed to take on one case. Now, for the last year to 2 years, the federal court has been looking very seriously at this issue of software patenting in Australia. And typically what the federal court has been doing has been taking this approach where they've been rejecting a lot of software patents on the basis that they don't believe that these inventions meet what's called a manner of manufacture requirement under the legislation. Now, a manner of manufacture has a meaning that goes back several centuries from UK law. Now, the problem with it is that it's bound up with common law, and common law mutates over the years. So as new inventions come out or as times change, the judge's interpretation of what manner of manufacture changes quite considerably. The federal court now has been taking the approach that a lot of software patents don't meet the manner of manufacture requirement because they don't have a very high level of inventiveness as far as what the court believes. Now, when they say they don't have a high level of inventiveness, what they're actually saying is if they hypothetically put themselves in the role of an IP professional, then the High Court would say that these inventions aren't typically inventive as per what an IT professional would regard as an invention in the computer space. They're more like what a person of the general public would regard as being inventive. And this is quite an interesting description of how things are going on, because there's quite a difference between what the general public would think an invention is in the computer space and what an IT professional would think is an invention in the computer space. Because an IT professional would look at it from the technical features that make up that invention, where a general public person would look at it from the outputs, or the marketing, or the spin. So if you look at something like Uber, for example, Uber is a very interesting project for the general public. For an IT professional, it's very simple technology. So something that, if for example you were to apply for the Uber technology right now, you probably wouldn't get it through the federal court. So there's been a whole list of decisions with the federal court where recently the federal court have just knocked down these software patents because they don't think that they have the technical capability of being an invention as per what an IT professional was regarding it as. And that's a very simplified way of looking at it. The federal court has also brought in a sort of a two-part test to assess whether the computer patents make their threshold. But this is a bit of an arbitrary test which the federal government has sort of made up, and it's not really reflected in the legislation. There's a recent decision in December 2021, Aristocrat, which is a poker machine gambling company, appealed to the federal court, or to the High Court, from the federal court decision. So they had one of their patents knocked out and they were appealing to the High Court. The High Court agreed to hear their case, which is highly unusual. And the hearing went ahead on the 8th of June this year. At the moment, the hearing has been completed and both sides had an opportunity to state their case. So the Commissioner of Patents stated his case and also Aristocrat stated their case. It's quite interesting that in this particular High Court decision, a lot of professional organisations representing patent attorneys actually put in briefs to the High Court recommending that the High Court look at this issue of software patents, but also most of those recommendations were siding with Aristocrat, partly because there is an overall belief in the patent attorney profession in Australia that the threshold for software patents by the federal court is too hard, and that it should be a bit more lenient because it's diverting from the original goals of what the Patent Act was there for. The goals of the Patent Act were there to protect new inventions of sufficient calibre to be protected. And that sufficient calibre is set out by being novel, being new, and being inventive. And those tests alone should make the threshold. The manner of manufacture test is quite a subjective test that the federal court is applying. So we hope that the aristocrat decision clears up some of this case, and it is our last hope. We're hoping that the decision will be handed down in about November this year. So watch this space to see what happens with software patents. I hope this helps you out and understand some of the issues with software patents in Australia at the moment. And rest assured, the situation will change. Probably provide another update in around November. If you need any more information about software patents, please feel free to contact myself, Anthony Alder, or anyone at Alder IP. Thanks for listening.